Hello, everyone. Now we're going to be talking about obligations, and this is essentially a rundown through the text that I provided you. I'm not going to go through everything, I'm going to go through the most important parts and try to provide it in a more accessible form. Really, the topic is really a very easy one. It's more panoramic and classificatory than substantial, but still that's very useful because it will give you a language to understand the flora and fauna that you find when you look at human rights texts. So first, let's say that when to talk about obligations, we must notice that there's a distance between the text and the actual obligations that exist. You need to go from the text to the norms. This is a process that we call interpretation. We see a text and the text says something, but to really understand what is the demand that is required from us, we have to interpret the text. So the right is really not the Article 2, the Article 3, the Article 4, not just simply that. The right is our interpretation of the normative content of Article 2, Article 3, Article 4. In talking about interpretation, we must note that the text of the rules can sometimes be under-inclusive or over-inclusive. This is something that you may already have heard from me in certain versions of the course Intro to Law. A text is under-inclusive where the text is substantially smaller in coverage than what is rational, reasonable, or desired. So you could say then that the text is smaller than the right. The actual right goes beyond the text. There would also be scenarios where the text is over-inclusive, where essentially what you see is that the text claims many, many things, but really the reasonable right will be something more special and more specific. Let's provide some examples. So for an example of a text that is under-inclusive, we may consider Article 5 of the African Convention on Human and People's Rights. This article, which I copied here and I will read for you, says, "Every individual shall have the right to the respect of the dignity inherent in a human being and to the recognition of his legal status. All forms of exploitation and degradation of man, particularly slavery, slave trade, torture, cruel, inhuman, or degrading punishment and treatment shall be prohibited." So the focus there is in prohibiting torture. It doesn't say anything about punishing torture or preventing torture, but I would say trivially that is implicitly there. That's part of the package, that's part of the deal. Another example, ISESCAR Article 11. This is one you've already heard about in the course. So this one states the adequate standard of living. It mentions food, clothing, and housing. It does not mention water, but of course, water is part of the package. Water is part of the deal. Once more, the article is under-inclusive. But what about over-inclusive? Can we find cases where human rights treaties have said more than they should have said? I believe so. So here is one that I find particularly irritating. Uh, the ISESCAR defines the right to health partially as this: a state party to the present covenant recognize the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. This is hyperbolic. It's not just utopian, it's just capricious, right? If I have a headache, I am not enjoying the highest possible standard of physical and mental health, but I would not consider that my headache is a violation of human rights. That's simply, in my point of view, just out of the question. So there you have it. Rights can be under-inclusive, or let's say better, the text of rights can be under-inclusive or over-inclusive of what a reasonable interpretation would say that the underlying actual normative content is. Another point that we must consider is that a single right can have more than one obligation attached to it. This is something that holds true independently of we're thinking about interest theory rights or will theory rights, to refer back to an older discussion. So we have a textual form The textual form says, something that may or may not be very clear, but the actual right, once we interpret it, might not have just one obligation. It might create a cluster of obligations. And then, for example, this is something that we see very clearly in Article 6 of the European Convention of Human Rights that we have already studied. This is the article encompassing the right to fair trial. And here we can see that it involves, fair trial, access to court, equality of arms, trial within a reasonable time. That in certain cases, if you're not able to fund yourself a lawyer, the state should provide you one, etc. So there you can see that a single right, we could call it fair trial, really is decomposable into a larger set of obligations. Let's keep going. Now we should move to the general classification of obligations. So this is something that really it's something that you will find in my text, but it will not necessarily be present in other texts. This is the reason I asked you to read my text. The text is, I won't say this is innovative because nothing about this is really groundbreaking. We all know that this exists, but the text takes the effort of putting it all in one place systematically. And in that regard, I think the text is useful for students. So let's say what are the sorts of obligations that we can find in human rights? One first thing we have to notice is that human rights will involve explicit and tacit obligations. So if you go back to the Article 5 of the African Charter of Human and People's Rights that we have already discussed, we can see that the prohibition of torture is explicit. It says so right there. However, other rights would be implicit. The right to water or the right that torture should be prosecuted are not explicitly present in the text, they are implicit in the text. You get them through interpretation, through textual inquiry into the meaning of what is written there. I want to let you know that the thesis that there is more to rights than what's literally written down is one that has official recognition. For example, Article 5 of both ICESCR and ICCPR, and this article is identical, it's a common article, says that there shall be no restriction upon or derogation from any of the fundamental rights recognizing or existing in any state party to the present covenant pursuant to law, conventions, regulations, or custom on the pretext that the covenant does not recognize such rights or that it recognizes them to a lesser extent. This is a way of saying the rights in the covenant as written do not exhaust the possible rights that may exist for a person. We keep going, we find the distinction between claims and freedoms. A claim is simply a requirement that somebody should do something or abstain from doing something, a demand or a prohibition. For example, the right to life is essentially a claim. The right to life means that my life should be respected, that threats to my life are prohibited, that nobody should arbitrarily kill me. So, in that case, let's say it's a negative claim. It's a claim that somebody should not do something, emphatically, should not arbitrarily kill me. There would also be positive claims. So, for example, that would be a claim that certain form of positive action is taken. For example, that the state should provide me with free basic education under the right to education. A freedom, by contrast, as opposed to a claim, is not fundamentally that somebody should do something or refrain from doing something. A freedom is simply something more complicated. A freedom is a permission that I have to do or not to do something, together with a restriction on others not to interfere with that freedom. And then the example here would be Article 9 of the European Convention of Human Rights. Everyone has the right to freedom of thought, conscience, and religion. That includes the freedom to change religion and to practice it alone or in community with others, to manifest it, and so forth and so forth. So it's pretty obvious when you read this article that it does not say that I must think, or that I must have a religion, or that I must express my religion, or that I must express exercise my religion in community with others. The point of this article is that I may think something or not thinking, that I may have a certain conviction in my conscience, but I can also abandon it, that I can have a religion and I can change to another religion, or simply decide that I do not want to have any religion, being positively atheistic or simply agnostic. Essentially, this is a freedom. What the right protects is my freedom to do or not do so I please. Others simply have to respect my freedom. The core of the right is that I can do it or not do it. Then defense of the right is that others, third parties, must respect my freedom. So that it is a different model for rights. This topic here connects very closely to the discussion of the interest theory and the will theory of rights. Now, without entering into too many complications, I would say that the interest theory of rights prefers claims. The interest theory of rights is more comfortable with the idea that rights are claims. The will theory of rights, by contrast, wants to see that rights are fundamentally freedoms. So it's up to you, up to your will, whether you exercise them or not. In practice, the law and philosophy are never the same. Like philosophy wants to be more pure, but the law typically is complicated and full of compromises. And the reality of it is that although for the most part international human rights law look more like interest rights, they're also freedom claim right they're also will theory rights, and then you do have a mix of claims and freedoms in the way that the actual law has developed. So let's keep going. Now we have to enter into the topic of rights being negative or positive, and the so-called topic of the respect, protect, and fulfill schema. So this is something that will have to qualify a lot of what I said earlier. So earlier I was giving you some categories, and those categories have been a little bit become less important because of the rise of the negative positive or RPF doctrine. The bottom line of this doctrine is that human rights have become multidimensional protections. So every right, right to life, freedom of speech, education, so forth, does not protect me only from state action. So the right to life is not just that the state should not arbitrarily kill me. And it does not protect me exclusively from state inaction. So the right to education is not exclusively the demand that the state should fund the schools. Really, it's a mix. For every right, I'm protected both from attacks and from abandonment, from, let's say, arbitrary interferences and social exclusion. Every right would have positive dimensions and negative dimensions. Or if you want to complicate it a little bit further, it would have a respect dimension, a protect dimension, and a fulfill dimension. Now, this is something that you see all across the board of international human rights system. Now, the language they use is slightly different. For example, the United Nations speaks of respect, protect, and fulfill. The European system talks about negative and positive. The Inter-American system talks about negative and positive. And the African system, like the UN, talks of respect, protect, and fulfill. But as you can see from the table, the coverage is the same. Now, the negative obligations and respect obligations are identical. So if I have the right to life, that means do not arbitrarily kill me. If I'm writing a book, do not censor the book. And the positive obligations, well, if you're in the European system or in the Inter-American system, it's not it's a broad category that includes all sorts of positive actions that the state must take to ensure your rights. For example, that the state must provide emergency warnings or allow you to exit a place where a landslide is likely. That would be one possibility, or that the state must provide you with funds to have a certain type of surgery, for example, a surgery to change your gender. That would all be positive. But on the United Nations and in the African system, the positive dimension is broken down into two sub dimensions: positive actions of protect and positive actions to fulfill. Positive actions to fulfill are quite simply that you do not enjoy something and the state should give you the funds so that you can enjoy it. the funds or the material or the support or the aid that you should enjoy it. So quite trivially, for example, if you do not have access to clean water, the state should provide you with clean water. The protect dimension involves a triangular relationship. The state must take positive action to protect the rights that you have from infringement from third parties. So there's three people in the game: the state, the assailant, and you. And the state must take positive action to intervene in such a way that the assailant cannot hurt you. Now, essentially, if you think of the protect dimension, think of police. Now, the state must provide police services, to put it in a very general way, to ensure that your rights are not infringed by third parties. Respect, protect, and fulfill, it's the dominant paradigm, and then it gives you the impression that all the qualification, for example, of claim and freedom is ultimately not all that important, because maybe all rights will, even freedoms will have elements of claims. Now, for example, my privacy would be fundamentally that I am able to choose to reveal myself or not. But potentially, if it has a protect dimension, it might also be that the state must take action to ensure that your privacy is respected, and hence then it has this claim dimension. Or maybe privacy even has a fulfill dimension. And then, for example, in the case of a person that needs to transition to another sex, because his own autonomy and self-determination require so, then in order to fulfill the right to privacy, understood as the right to your private life, to understand yourself in your private life as you so wish, the state may need to fund that operation. So once you enter into this negative and positive respect, protect, and fulfill paradigm, the story of claims and freedoms becomes somewhat less important, because really even the freedoms will have some claim dimensions attached to them. So this is the dominant paradigm. In the text that I provided you, I give you some criticisms of that paradigm. The criticisms are not meant to be final, they're just meant to provoke your thought, because this paradigm has become so dominant that it's become almost impossible to think of human rights in a different way. But the paradigm comes with its side effects. It has some negative side effects, and I suggest that you look at them in my text. Let's keep going a little bit further. Now, here is something interesting: factual and institutional obligations. To my knowledge, I am the only person that have noticed these ones and give them a classification apart. Of course, everybody knows that they exist, but they have not been classified as such. And I think it's helpful to classify them. So most human rights obligations refer to the real world. They are factual obligations. Do not kill arbitrarily, provide healthcare, provide water access, provide access to education, do not censor my book, that is, allow the book into circulation. However, some obligations are not about the factual world of stones, chairs, and people, bodies of people, but are about the institutional world. The institutions, the sort of, let's say, imaginary labels that we put into reality, and also of the laws. And then some obligations say that certain laws cannot be in place, or that certain laws should be in place, must be in place, or that certain institutions cannot exist, or that some institutions must exist. For example, in the LGBTI, let's say in the gay marriage debate, the issue for same sex couples is not something material, not primarily, because in many scenarios they actually have access to the same material benefits as married couples. What the struggle has been is for the institutional recognition of marriage as something that must be necessarily available for them. So that's not about the world of facts, rather, it is about the world of institutions. That a certain institution, that is, LGBT marriage or same sex marriage, must exist. In addition to that, or let's say in the opposite to that, this example is one, of course, that's anachronistic, because we have not have formal slavery anymore. But an example would be that nobody can be held a slave. That the legal institution of slavery, that the legal category slave, cannot exist. That an attempt to enact this legal category and render a group of persons into objects, that is simply something that can never be allowed. So, of course, we still have, let's say, modern forms of slavery, but the modern forms of slavery are factual and not institutional. So the institutions say that there are no slaves. Some people are as if they were slaves. They are modern slaves because their reality there is in such under such power and control from let's say from others who do not literally own them but in practice have so much power on them that it is as if they own them, and then that is how some form of a slavery survives, and the numbers of modern slavery are actually tremendous. So, actually, as an aside, I suggest you take a look at that phenomenon because no, for all our beliefs that slavery is over, you could say slavery is over in law, but it's thriving in practice. So, give it a look at that. So, that is, let's say, institutional obligations. And I would say institutional obligations are special because you see, if going back a little bit, this part over here, the protect, fulfill, the positive they mentioned, they are problematic, and this is something that I already talked about in the social rights lecture. They are problematic because they depend on the scarce resources. And then they say, well, negative obligations are special because negative obligations do not depend on scarce resources. You can always fulfill them, but positive obligations must be subject to progressive realization because they depend on scarce resources. Well, that is not true for institutional obligations. Institutional obligations, when they're positive, so for example, create this institution, create same sex marriage for same sex couples, that may be positive, but it's not subject to resource constraints. In one day, with a stroke of a pen, you can create the institution, and that's all that's needed. So that makes them a little bit special. Maybe practically that's not very interesting, but theoretically, within certain realms of work, it is quite important and interesting. Now, let's keep going just a tiny bit further. So let's talk about immediate, progressive, and programmatic obligations. So immediate obligations are the ones that we can ask right now. For example, the prohibition of torture. I can simply demand right now that the state stops torturing. That's something that makes sense to demand immediately, and something for which the expectation of compliance must be, let's say, inflexible. You do not say, if no, let's say, imagine you have a state that has tortured 300 people in 2019, and then in 2020 they say, well, today we tortured only 100 people. That is a tremendous reduction in the rate of torture. That is simply not an excuse, because what we demand immediately, what we demand right now, is that torture stops, that torture is zero. One case of torture is enough for there to be a violation. A reduction in cases of torture, even if it's a drastic reduction, does not in any way change the obligation, which is an immediate obligation to achieve zero torture. Aside from immediate obligations, the law also will provide you with progressive obligations. And these are obligations where compliance can only depend on the passage of time. And here again, we talk about those social rights that we have presented in the other lecture. Because social rights, dependent as they are on policy measure and material resources, the idea is that they can only be progressive. Now, for example, reduce infant mortality, reduce maternal mortality, achieve, let's say, universal coverage for water piping, or achieve universal coverage for primary education. This is something that can only be achieved progressively. You cannot take a country, say Uganda, and say, okay, you sign the ISESCAR right now, give me 100% access to primary education. That is not feasible, that is not realistic, and it's not good, neither politically nor morally, to hold the states accountable to impossible standards. Then what the law will assess in those scenarios is whether there has been sufficient progress. For the longest time, that effort has been, very weak. because lawyers do not really have the right tools to assess sufficient progress. Lawyers can say, well, it looks to me that things are getting better, but I'm not quite sure. With the advance of, let's say, measurement tools, and especially now that we're living in the era of big data, now we have an abundance of indicators that can be used to seriously assess where countries have been progressing in their social rights obligations. And it does not necessarily have to be social rights, but it would be mostly social rights. Whether countries have been progressing in their social obligations, their progressive obligations, now that can be seriously assessed. And if you're interested in that topic, I would say now it's the time because the tools are finally here, and it's just very recently that people are starting to use them. Next in line, we have programmatic obligations. Now, programmatic is a technical word. It means, means it's left open. You still need to fill that in. The content of this needs to be defined. It's no to be determined. A little bit similar to be announced. These are obligations that, in the way they're stated, they need to be filled in by secondary legislation because otherwise they're like a blank check. I do not know what they mean. Now, programmatic obligations, a lot of people will deny that they exist because they think that they can interpret some content or meaning to them. I disagree. The reality is that they do exist, and then some clauses, because you see, some clauses are vague, but there's different levels of vagueness. And programmatic happens where the level of vagueness is so high that without a political decision, you cannot really know what needs to be done. So here's an example. Article 3 of the Declaration of Right to Development, that's a non-binding document, but do not worry because the point is to exhibit the taxonomy, not to worry whether it's binding or not binding. And it's a great example for taxonomical purposes. Article 3, Part 3 of the Declaration of Right to Development states, states have a duty to cooperate with each other in ensuring development and eliminating obstacles to development. States should realize their rights and fulfill their duties in such a manner as to promote a new international order based on sovereign equality, interdependence, mutual interest, and cooperation among all states, and encourage the realization and observance of human rights. Okay, so you see, when you enter into the details, the reality of it is that, let's say, a new, more fair international economic order can be there can be so many versions of that. What do you mean? Something that's more based on sovereignty, something that's more based on interdependence, something like expanding the EU to all countries, an alternative model more based on sovereignty, like let's say the ALBA program in Latin America, well, in some Latin American countries, something completely unheard of, some sort of more ecologically based new international order. What exactly do we need to do in order to promote this? There will be some people that will say, yeah, I get it. That's what the WTO's been doing. The point of the WTO is to achieve economic development. It does respect sovereignty. It creates interdependence and it fosters cooperation and mutual interest. That's what the WTO does. Well, if you ask most of the human rights community, the people that say we're part of the human rights community, and you tell them that that's what the WTO does, they will be very angry at you because they will say, no, no, the WTO is completely the opposite. WTO is horrible. But the point, and the point is not a political the point. The point is one about legal technique. The point is that if you read this Article 3 just in itself, it cannot rule out exactly what form that cooperation, interdependence, and mutual interest and equality will look like, because there's going to be many versions of that. In order to get that moving, you're going to need secondary documents that will give fullness of sense to what's written down there. Now, this one's pretty easy, primary and secondary obligation. A primary obligation is just all the obligations that we have considered so far. So the right to food, water, housing, property, freedom of speech, education, religion, and so forth. Those are our human rights. Secondary obligations are the obligations that arise when the primary obligations are breached. Another way to speak about this is these are the remedies that should happen when your obligation is breached. So you have a right to life, but now the person has been killed. So now what? You have a right to property, but your property has been expropriated without compensation. That is, it has been confiscated. So what? You have your right to freedom of speech, and your book has been censored. Or let's say even more severe scenarios, a town experiences a wholesale massacre, as in the Plan de Sanchez case in Colombia, part of in Inter-American Court of Human Rights. It was not in Colombia. Las Palmeras was in Colombia. Apologies for the mix-up. But then, okay, what happens when you have a violation of your primary obligation? Because your primary obligation, maybe now that it has been breached, you might not necessarily be able to undo what has been done. You need to provide remedies, and the remedies are this alternative obligation that arise. So you had this first duty, you breached that duty, but now you have the duty to make good on the duty that you breached. And generally accepted in international human rights law is that you have at least four forms of secondary obligations, or let's say so four forms of remedies: compensation, restitution, satisfaction, guarantees of non-repetition. So compensation is pretty obvious. Compensation is monetary payment for the damage done. And then we have seen, for example, that compensation in the field of human rights is very often underwhelming, that the European Court of Human Rights is characteristically stingy in awarding financial compensation, but it certainly must be one of the possibilities on the table, the award of compensation for human rights violation. In some scenarios, but very few scenarios, that will be enough and it will be optimal. For example, if your book has been censored, maybe compensation is something that is acceptable, or if your property has been taken away, compensation might actually be the ideal remedy because I pay property with property. More significant than that, we have restitution. Restitution is a very broad category. I prefer to call, maybe because my background is more on local law, I prefer to call it injunctions. And restitution is simply that the court makes an order to repair the situation, but by the state having to do something. No, and then as opposed to paying money. Of course, technically paying money is doing something, but in law we distinguish doing something, let's say injunction, versus paying money, which is just transfer of funds. And restitution is typically seen as much more powerful. And the example, or the classic example where you can see this immediately, let's say a person has been imprisoned without trial, unfairly imprisoned, then let's see, well, compensation. So here's 3,000 euros that may help you buy cigarettes in prison, but you see that's not appropriate. What is appropriate if a person has been unfairly imprisoned is to set the person free, and that's what restitution is about. Restitution just means you set the person free, that you take the action that repairs or heals the human rights violation. Now, the case of a person that's put in jail and then set free, that's a very easy one, but restitution also has a role to play when you have gross and systematic human rights violations, violations that cannot be undone. Because you see, setting the person free in the case of a person that is unfairly in prison undoes the violation, and then it's like 100% real restitution. But in some other scenarios, restitution measures of restitution cannot undo what's being done. And then what they do is, they order the state to take positive action to compensate somehow in non-monetary terms, but through actions, the damage that has been done. So in one of the early cases of the Inter-American Court of Human Rights, a case where I believe around 10 people of the Saramacca tribe were killed in Suriname, then the court faced with the remedial problem, and then of course compensation is not a it's not it was ordered, but it's not 100% appropriate, because this is the taking of life. This is a gross human rights violation, and restitution, of course, it would be called for, but then there's no way to bring the people that have been killed, there's no way to bring them back from the dead. So restitution, then the court takes a more aggressive measure to ensure that the state behaves in a fair and equitable manner. And in that case, in that scenario, for example, what the case is called Alubutu, In that scenario, what the state did was order the creation of a medical facility, of a medical dispensary in the place where these people were killed. And then you can see that it's a way, this is considered to be a way of transitional justice, a way to take action to deal with the gross human rights violations that they have caused, even if it cannot erase them, but at least acknowledge them and take positive action to honor, in this case, the victims and the survivors. Then we have satisfaction, and satisfaction is not very interesting. Satisfaction is just measures that are moral in nature and that are just the recognition of the violation, and they serve as some moral compensation for the victim. So, for example, if your book has been censored and the censorship was undue, then you might say, well, then the court proves that your book was not hate speech, that your book was just critical and legitimate speech. Then the court might say that that in itself is a form of compensation because you've been vindicated. And I don't want to minimize it because there's a huge element of recognition and it's part of the idea of dignity, of course, the idea of recognition. But compared to the other remedies, this is not a very strong one. And finally, guarantees of non-repetition. Guarantees of non-repetition is extremely special because the main idea of remedies typically is to repair the harm done, and it looks at the victim. But guarantees of non-repetition goes far beyond this. Guarantees of non-repetition says it's not enough to repair the harm done. We need to make sure that this not does not happen again. Maybe the victim is not even here anymore, but we need to make sure that there's no new victimization. We need to make sure that the state mechanisms change to make what has happened impossible that it would happen again. And this is very powerful. It has been used to powerful effect by the Inter-American Court of Human Rights. And then, for example, a classical guarantee of non-repetition is that in the case of police brutality or police excess, the court may order the police to undergo certain human rights training and to ensure that it has adequate supervision so that the type of violations that occurred do not occur again. So guarantees of non-repetition is very interesting because it, instead of looking to the past and instead of looking only to the victim, it has this amplifying effect to the future and to the society at large. So guarantees of non-repetition, very interesting and very powerful. Now I'm going to enter to a category that deals with essentially very weak obligations, adverbial obligations, and well, really non-obligations. And these obligations, I think they're very important because the way they're worded is so marginal that if you look at them carefully, you say, well, no, that does not seem to mean much. No, adverbial obligations. Well, what is an adverb? An adverb qualifies a verb. An adverb tells me how something must be done. No, I must carry the eggs from the supermarket home carefully. The adverb carefully, no, that is how I must take the action. Then some human rights obligations are essentially adverbial in character. They do not give me one particular conclusion that must happen. They don't even say that I have to take this action. They just say that when I take the action, I must do it in a certain way. And that is, if you think about it, that is tends to be a very weak obligation. For example, treaty body recommendations or treaty body views, well, they're not binding, but there's an adverbial obligation that they must be considered in good faith. That if a state has an opinion from a treaty body or it has a view of a treaty body, it must implement it. And then if it does not implement it, it must explain very carefully why it rejects the view or why it decides not to implement it. Because all the exchange between the treaty body and the state must occur in good faith. And if you think about it, that tends to be a very weak obligation because it does not mean that the state must implement the treaty body recommendations. It just means that it has to take a good look at them. And it's very hard to know what is to take a good look at them, what is to look, consider them in good faith. It's very something that's very hard to assess. However, I still would say adverbial obligations can be powerful because they can be powerful in, let's say, in very there may be situations, they can be circumstantially powerful, because there will be situations in which it's completely impossible to argue that the state has satisfied the obligation to make the analysis in good faith. That, for example, if there is a case against Tajikistan that deals with enforced disappearance, and the state gets a petition to and to an execution, and the state gets a petition to reveal the location of the person and to stop execution, and then the state simply says nothing, nothing whatsoever, and then of course the execution gets carried out, and then you could say, well, maybe I had, maybe the obligation that arose from the views of the committee, you could not say that it was really an obligation to stop the execution, because committee opinions are non binding. But if there was no discussion whatsoever, if there was no engagement whatsoever, no evidence presented that the execution was somehow legal, if there was no reaction from the state, then you could say this adverbial obligation, as weak as it is, has simply been violated. In addition to adverbial obligations, I also want to mention non obligations, and this would be principles or values that have to be taken into account but do not petition for any specific outcome. An example would be the principle of the best interest of the child. The best interest of the child is not any concrete obligation. It does not mean that I have to do this or that. It just means that wherever I interpret the convention, I must take the best interest of the child in play. These are human rights principles. They are part of human rights, but strictly speaking, they are not obligations. They are very important, and like adverbial obligations, they can even be decisive in in the right context. So if you want to read more about principles, or if you want to see the distinction between rules, that is obligations, and principles, there is a lecture on that topic. It's not from this course, it's from another course, but it's one of my favorite lectures for whatever reason. It's probably not very nice, but I like it. So please go check that one out. So, and our final, and I for this I can be very brief because we have discussed this quite at length. We can also classify human rights obligations according to their stringency. And here we have absolute obligations, and typically this would include recognition of personhood, recognition of all persons are persons, and that slavery is prohibited under the law, and that torture is absolutely prohibited. And there's no case where you could have, let's say, human beings that are treated as not being human beings, or that you can have no scenario where slavery is permitted, or that you can have no scenario where torture is permitted. So these would be absolute obligations. You Let's add another one: freedom of conscience. The state could never act against your conscience. The state should never interfere or breach your conscience. These are obligations that is generally accepted, hold absolutely no exception. Next down the ladder, you would have obligations that are not absolute but do not implicitly allow limitations. And these obligations, the idea is that they can be limited but only in very exceptional cases. The example here will be Article 6 of the European Convention of Human Rights, the article on fair trial. And then if you see the article on fair trial, it does not say that it's an absolute right, and the court allows in some scenarios limitation of the article of fair trial, but you would take it that these limitations would have to be very exceptional, because the article itself does not open the path for limitations. And then third, going lowest in the scale of stringency, you would have rights like the right to privacy, the right to freedom of expression, or the right to property that explicitly allow limitations in law. And then these rights are, you could say, expressly limitable, or you could also say they're qualified rights. We know already that these rights do not exist alone, that they exist in relation to the public interest, and that they always have a limit in the public interest. So here you could have a distinction of rights according to their stringency. Now, I think that is all for today. So as you have noted, I've had to open and close my editing software. I will try to edit it out, but so far I have not been successful. So you will just have me clicking on that occasionally or checking to see that it's running, but it should not be a big deal. Thank you very much for your attention. Everything that's here is also on the separate file. It's just that here is probably just a nicer way to hear about it instead of reading it, except the discussion on the potential negative effects of this respect, protect, and fulfill doctrine. So there is a little bit of an aside there where I give a little bit of reflection on that. This doctrine has been generally been positive, but as things are in the real world is very complex, and some things that are positive can have negative side effects, and it's worth looking at that. So thank you very much for your attention. See you very soon.